Wendy, first of all, I want to ask you, as a judge, as a former judge at the Old Bailey, have you experienced giving a sentencing statement like we heard today to an empty dock, where you have to address the defendant is not there?
Yes, I have. I've done it, but not in those circumstances. I've done it in circumstances where the defendant has thought it unwise to come to court because of the strength of feeling that was being evinced against him and felt that there would be violence in the court. I've dealt with it in circumstances where a defendant is mentally unwell and unable to come to court for that reason. I've never dealt with one quite like this.
Can you, I suppose, imagine then, Wendy, that it would be odd or slightly jarring for a judge in this context to be facing an empty dock? Based on your experiences, is that slightly strange?
It looks strange, Callum, but I don't think the judge would have been put off by it at all. A sentencing exercise like this is extraordinarily complex, and the judge has to get into his remarks so many things in law. He has to get the law right, has to get the facts right, has to get the principles right. He has to apply the facts to the law. And every word that he has said today will have been the subject of very, very careful thought by him. He will have worked it all out, and it will all be written down. So I don't think he will have been in the least put off by the fact that she wasn't there. But of course, it looks very odd to those in the courtroom.
Stay with us, Wendy, because I want to bring Anna into the conversation, and do feel free to speak to one another as well. Anna, I want to, at this point, just understand the psychological impact on a day like today, where there is an empty dock, where the defendant is not there. I suppose one of my immediate thoughts is that this must be such a personal thing for victims or their families when they're reading out these statements and the dock is empty. Can you just explain to us, Anna, about the psychological impact in these sorts of situations where a defendant is refusing to appear?
I think that what you have to consider is that the families who are so traumatized and have been put through such incredible pain do have a real wish to see justice done and to see the person, to look into the eyes perhaps of the person who has taken away their loved ones. There are terrific motivations for wanting to see justice done, and sometimes it's about revenge and punishment, which is a part of justice. It's not unusual, however, for people who have committed crimes which are extraordinary and where they may have been very disturbed psychologically to find it extremely painful or unbearable to be present at hearings. However, I think that the questions you're asking are about what is the impact on the families, on the victims' families, to not be able to see the person whom they have entrusted the care of their children to, their babies, their vulnerable babies. And there's a sense, I think, for them that closure hasn't been achieved, if there can be such a thing in a case.
Of course, and it is such trauma to deal with. And Anna, with that in mind, can there be any impact on the defendant of appearing and hearing the impact statements in person? It strikes me that in a case like Lucy Letby's, that how on earth do you ever break through such mental disturbance that that has contributed to her actions? Would a victim impact statement simply be water off a duck's back? I suppose, is there any positives in having a defendant in court on a day like today?
I think on a day like today, it wouldn't be possible for the defendant to really take anything in. And the question has to be asked, if somebody's capable of committing these kinds of acts with that degree of psychological detachment or disturbance that one imagines must have prevailed, then an ordinary response to being told that one is culpable and sentenced to a whole life imprisonment is simply impossible for them to hear or take in or process. As a psychologist, I would certainly want to be working with someone to help them bit by bit process what they have done, if that's even going to be feasible. But on this day, when there's so much shock and horror, I think that the kind of understanding that we'd be wanting, the kind of signs of remorse and horror at one's own actions, are just, that's simply a bridge too far. So the real question for me is about what it means to the victims' families and what they might have hoped for, and this sense of, I think they might feel someone's gotten away with something.
Yeah. Wendy, that's an interesting thought, isn't it? Because there is this principle, isn't there, of justice being seen to be done. And I suppose that comes with its own complications. As I was considering this earlier and looking forward to speaking to you, Wendy, I was quite taken by the idea that we could watch or indeed listen to the judge today delivering his sentencing remarks. And while that does allow for justice to be seen to be done, it's almost as if there is an insatiable public appetite for it to be more public, if you see what I mean, in that there's this seeming desire for Lucy Letby to have been there. And I just wonder if by making these proceedings public, our thirst cannot be quenched with how much we actually want to see.
Yeah, well, that's a really interesting question. I think perhaps the first thing to say is how much, I use the word satisfaction with hesitation, but how much satisfaction the victims and the families could have got if she had been there really depends on how she behaved if she was there. If she'd stood there full of remorse and weeping and expressing how sorry she was, it would have been one thing. But I think we can all agree that that was never going to happen. If she walked in and used it as a platform to declare her innocence and to shout that the jury had got it all wrong and that the whole thing was a farce, well, that would have been even more distressing. If she refused to listen, she'd sat there with her fingers in her ears and her eyes closed. What can a judge do? Can he force her eyes open? So how much it really helps to have her there is will vary in different cases. But I think it is just worth asking yourself, Callum, what the sentencing exercise is for. It is one of the most solemn and important moments in a trial, because it's the moment at which the judge sets out the facts, sets out the sentence and the rationale, his findings for what he's doing. And he is addressing not just the defendant, not just the bereaved, the victims, but he's addressing all of us. This is a Crown Court, which is the court where the prosecutions are brought in the name of the public. It's not like a civil court where it's one person against another. We all have an interest in this. We are all represented by that jury because they are us. They are people whose names are on the electoral register and who were called for jury service. We all have a vested interest in hearing what was happening there. And the idea that somehow a defendant, and I'm not talking about Letby at the moment because I just don't know enough about her to know how she would have behaved if she'd come into the dock, but the idea that a defendant can hijack proceedings, make themselves the center of attention, and turn it into some sort of circus is distressing beyond belief. So whilst I completely get why people are saying she should be there to see the damage that she's done, if there is going to be a change in the law to somehow make it compulsory that she's there, it needs to be thought about incredibly carefully, because what you have to take on board is you can make it compulsory, but you may not be able to do that. So that you may have to say, this is the law, you must be there. But you are then going to have to say, and if you are not, there is a penalty to pay for it. There is if you don't stand up and listen to what's going on, then you're going to have to pay some other penalty for it. And that actually is what the Justice Secretary was saying. He wasn't saying quite what the Prime Minister is saying, which is we're going to make people go to court. He was saying we will change the law so that they must go to court or pay the penalty of not going to court, pay the price of taking that attitude. And that's not quite the same thing.